So hello guys. So welcome to this previous year polity questions. Okay. So we started with Parliament. From the Parliament, since last 10 years, we have got 25 questions, and we completed all those questions. Later, we started with this fundamental rights, fundamental duties, and DPSPs. So from these three chapters, we have got 28 questions. So out of 28, we have completed 20 and we are left with 8. So today, it's turn for those 8 questions. Okay. So let's see the first question for the day. Under the Indian Constitution, concentration of wealth violates right to equality, the directive principle of state policies, the right to freedom, and the concept of welfare. See, actually, concentration of wealth. Okay, so there is an article called Article 39, which comes under DPSPs, Directive Principles of State Policies. Okay, so in this Article 39, we have 6 clauses. So first clause is a right to adequate means of livelihood. Means of livelihood. Second one is distribution of material resources, which means the land, water, air, material resources for the common good, which means state should distribute the material resources for common good, which means like only one person shouldn't be holding thousands of acres. Okay, it should be like each and every person is holding minimum 1 acre. Okay, and the third one is prevention of concentration of wealth. Concentration of wealth. So this tells us like it shouldn't be like only few people are rich and remaining all the people are poor. Okay, it should be like each and every person should carry some or the other amount of money. Okay, so this is the prevention of concentration of wealth. And D is equal pay for equal work. Equal pay for equal work. And E is protection of health and strength of workers. Health and strength of workers. And better conditions for children growth. Better conditions for children growth. And here we need to take care of the nutrition of the children as well. So these are the 6 things which are there in Article 39, and this is the lengthiest article of DPSP. Just like we have Article 19 in fundamental rights, this is the largest article of fundamental rights. Similarly, Article 39 is the largest article of DPSPs. Under that, the third clause, which is clause C, is saying that prevention of concentration of wealth. So your answer is directive principles of state policies. So option B. Okay. So the next question is, what is the position of right to property in India? See, now here I'll explain a bit about right to property. So, if possible, note down on a paper, right to property. Right to property. Say right to property, before we used to have in 2 articles. One is Article 19 clause 1 clause F. 19 clause 1 clause F. It says that every citizen has right to hold, right to acquire, right to acquire, hold, and dispose the property, which means you can buy, you can own, you can construct building, and you can sell the property. So this is the right given by the constitution to the citizens. And one more right is article 32. Article 32 is also comes under right to property. So here what happens is, here it says no person shall be deprived. So here it is talking about citizen, it is talking about person. No person shall be deprived of his property, his property, except by the authority of the law, except by the authority of the law. Ante, which means state can acquire your property only if there is a law. Okay, let's say you have 12 acres. Meanwhile, government came up with a law stating so maximum a person can hold 10 acres only. Then you have 2 acres extra. Then by following the law, state can acquire your property. But while acquiring, first one, it should be for public purpose. It should be for public purpose. Example, if they are laying a road or if they are constructing a school in the place of your land, okay, then only for the public purpose only it can acquire. But the second important thing is, whenever they are acquiring, they need to provide compensation. They need to provide compensation. So this is right to property, which used to be in our constitution. Later what happened is, 44th Constitutional Amendment Act came 1978, and through this Constitutional Amendment Act we repealed, which means we removed these two articles from the Constitution, 19 clause 1 clause F and article 32. Article 32, both we have removed, and we replaced right to property in article 300A. Article 300A, which means now this is a constitutional right, not a fundamental right. Okay, here what happened is, same text has written no person shall be deprived of his property except by the authority of the law. Okay, and here they are not talking about the public purpose, and here they are not talking about the compensation as well. So here in this case, if they are acquiring your property, they may provide you compensation. If they are providing you the compensation, that compensation may be 30%, 20%, or 10%. If the state doesn't has money, it won't provide you compensation as well. So this is article 300A. Okay, so this is all about right to property. Now with this knowledge, we'll solve this question. What is the position of right to property in India? So now they are asking about article 300A. Okay, now article 300A, because article 19 clause 1 clause F, it is repealed, and 32 also it is repealed. So see, this is the legal right which is available only to citizens. See, I have told you no person, which means it is available to any person, not only citizens. So any person, so legal right, this is not a fundamental right. See, this is not a fundamental right. Fundamental right means it has to be in part 3. Okay, from between articles, article 12 to article 35. But actually article 300A, it is in part 12, under the financial relationship between state and center and state. Okay, so your option is here B. Okay, so this is your option. Okay, so this is all about right to property. And next question is, with reference to the writs issued by the courts in India consider the following. Okay, so mandamus, he's talking about mandamus. Mandamus will not lie against a private organization unless it is entrusted with a public duty. Mandamus will not lie against a company, even it may be a government company. Okay, and third one is any public minded person can be a petitioner to move the constitution, to move the court to obtain the writ of quo warranto. So try to solve this question. Meanwhile, I'll explain. See, basically, he's talking about mandamus in the first two things. See, mandamus is applicable to government officials, not to private individuals. Private individuals. Not to private individuals, and it won't apply to government companies as well. So it is applicable only to government officials. Okay, so here what he's talking about is mandamus will not lie against a private organization. Yes, it is true. Mandamus will not lie against a company even though it may be a government company. So it won't applicable to companies as well. And third one is any public minded person can be a petitioner to move the court to obtain the writ of quo warranto. Okay, which means, see, quo warranto means, let's say this person is A, okay, he is into public employment. Now anyone can question on what authority you are holding this position. So quo warranto, any public minded person can question this. So your option is, all are correct, so option D is your answer. Okay, so give me a minute, guys. One moment, let me check the question. Okay, so I feel like there is a mistake in the question, so let me check it once. Yes, there is no mistake. Fine, good to go. So this mandamus, you need to remember two important things here. It applies only to government officials, not to government companies. Not to government companies. Okay, and one more thing you need to remember here is, in the writs only habeas corpus is applicable to both private and government officials or individuals. Okay, so here these three statements are correct. Next question, in essence, what does due process law means? See, due process of law means simple, the principle of natural justice, guys. Because see, what it is talking about is, due process of law, there are two things: procedure established by law and due process of law. Due process of law. So before, this is mentioned in article 21. Okay, so here in Maneka Gandhi case, okay, so government, I mean Supreme Court told that procedure established by law means not procedure established by law, instead it is due process of law, which is given in USA Constitution. So they will follow the principle of natural justice, because see, procedure established by law means there will be a law. Now court will check the arbitrary action of only executive, whether he is following the law or not. By following the law only he is doing the things or not. But here court will check two things. One, the arbitrary action of executive, whether they are following the law or not. Second thing is, they'll check the law as well, whether it is following the natural justice or not. Let's say you have not wear the helmet. Okay, so for that maximum 135 rupees fine is natural justice. Okay, if they are charging you 1 lakh rupees, then this is against natural justice and this is irrational. So this natural justice, what it will do is, it will check the arbitrary action of legislature and the irrational laws. Okay, so this article, question number 24, the answer is A. Okay, next question. According to the Constitution of India, the central government has duty to protect states from internal disturbances. Yes, true. It is the duty of the state to protect. Article 365 says it is the duty of the state to protect, center to protect states from external threats and internal disturbances. Okay, first one is correct. The Constitution of India exempts the state from providing legal counsel to a person being held for preventive detention. So this is correct statement. And here this is, see, we have two types of state detentions. One is preventive. Second one is punitive. So in the preventive, whenever you are arrested, you have some rights. You need to know about the grounds of your arrest. First one. Second one, within, you need to allow, like you are allowed to consult your legal consultant, which means your advocate. And third one is within 24 hours, you need to produce in front of magistrate. You need to be produced in front of magistrate. But here in the preventive detention case, grounds has to mention, but in the public interest they cannot mention as well. Okay, second one is, they'll allow to meet your legal consultant, which means your advocate. They'll allow you to meet your advocate. Third one is within 24 hours. This is not mandatory. So here they can keep you in the bars till 3 months. Okay, so after 3 months, if they want to extend the period, then they need to consult the advisory board, which contains high court level judges. Okay, so here what he is saying is, the Constitution of India exempts the state from providing legal counsel. Legal counsel means within 24 hours you need to be submitted in front of the magistrate. Yes, for preventive detention, the Constitution exempts this. Article 22 in the Constitution, it is exempting this 24 hours. Okay, this thing for the preventive detention. So this is correct. And the next thing is, third statement is, according to the Prevention of Terrorism Act, confession of the accused before the police cannot be used as evidence. Actually, see, this Prevention of Terrorism Act, it came in 2002 and it was repealed in 2004. Okay, in this, what they have mentioned is, see, if me as a person, if I am committing my crime in front of a police person who is ranking SP or above, okay, then that will be considered as a proof, evidence. Okay, so here it is saying it cannot be considered. So this statement is wrong. So two statements are correct. So only two statements are correct, and your answer is option B. Okay, answer is option B. Next, consider the following statements. The Supreme Court of India has held in some judgments that reservation policy made under Article 16 clause 4 of the Constitution of India would be limited by Article 335 for maintenance of efficiency of the administration. Okay, see, you know, right, here he is talking about two articles, guys. Okay, so first one is Article 16 clause 4. Article 16 clause 4, it provides reservation for SC, ST and OBC in government jobs. And one more article he is talking about is Article 335. Article 335. See, Article 335 states that Constitution recommends Constitution itself is recommending state, which means both union and state government, to provide reservations for SC ST. Okay, but but these reservations shall not compromise administrative efficiency. So yes, it is good to go that you are giving the reservations to the SC ST, but while giving reservations you need to keep something in the mind, that is that you cannot compromise the administrative efficiency. So that's the reason in Indira Sani case, Supreme Court 1992, Supreme Court kept a reservation cap of 50%. You cannot exceed the reservation above 50%, because if you are exceeding 50%, then obviously it will affect the administrative efficiency, which means you are promoting the reservation. So people without knowledge, they'll come into the jobs. But whenever they are coming, then the administrative efficiency will come down. That's the reason. Okay, so this article is suggesting, okay, so you need to balance both reservation and the administrative efficiency. That's the reason Indira Sani case, Supreme Court said the reservation should not exceed 50%. So with this knowledge, you can solve this question. See, one, yes, the Supreme Court of India held in some judgments, reservation policies made under 16 clause 4 of Constitution of India would be limited, yes, by 335. I have already told you. So maximum 50% only you can give. This Supreme Court told in Indira Sani case. So this is limited by Article 16 clause 4 is limited by Article 335. Yes, right? For maintenance of efficiency of the administration. Article 335 of the Constitution of India defines the term efficiency of administration. So it is not defining the term. Actually, it is asking the government to balance reservation and administrative efficiency. So this is wrong. Option 1 is, statement 1 is correct. So here, okay, this is your option. Statement 1 is correct, but statement 2 is incorrect. Okay, and whenever this is incorrect, this cannot be the correct explanation of statement 1. So this option is also wrong. Okay, so obviously your answer is C. Your answer is C here. So with this, okay, so keep one more thing in the mind. So this part 16, okay, so part 16, it is talking about part 16, it is talking about special provisions for certain classes. Special provisions for certain classes. When I say certain classes, SC, ST, OBC. So articles covered in part 16 are Article 330 to Article 342. Article 330 to Article 342. And what it is talking about is providing reservations for SC, ST, OBC in government jobs, educational institutions. Okay, so generally people will struggle to remember this part. Okay, so part 15, again it's quite simple. Part 15 is election commission articles from 324 to 329A, and the very next article is article 330 to 342 is part 16, which provides special provisions for certain classes. When I say certain classes, SC, ST and OBC. So with this question you can remember this part of the Indian Constitution as well. Okay, fine. The next question is, under which of the following articles of the Constitution has the Supreme Court of India places a right to privacy? See, I have told you, I mean, this question, it has repeated for thrice in the last 10 years. Okay, so it is your Article 21, right to life and personal liberty. So in case Puttuswamy case of 2017, Supreme Court said right to privacy is a part of Article 21. Okay, and we are left with one more question for the day, and this is the last question for the day, which is a writ of prohibition. See, prohibition means prohibition writ is issued by higher courts to the lower courts. Okay, when the lower courts, they are working out of their jurisdiction, higher courts will issue a writ to the lower courts to stop the process. Okay, so to stop the process. Certiorari is different. Certiorari is issued by higher courts to lower courts to cancel the judgment. When judgment is delivered, then certiorari comes into place. When the judgment is in process, then prohibition will come into the place. So simple. So it is talking about government officer prohibiting, no. Parliament, legislative assembly to pass, no. The lower court prohibiting continuation of proceedings in a case. Yes, this is the correct statement. So in the prohibition, higher courts will issue a writ to lower courts to stop the process, to stop the process. So with this, we are done with all the previous year questions of fundamental rights, DPSPs, and fundamental duties. So total we have got 28 questions, and I have covered all the 28 questions. So thanks a lot, guys. So in the next session, I'll come with this preamble. Okay.